When it comes time for pay raises, cities and towns sometimes grumble about lieutenant pay. A common proposal that management puts forward is ending hourly pay for lieutenants and making them salaried employees. As much as government entities want to save money, making lieutenants salaried is most often illegal under the federal law known as the Fair Labor Standards Act, the FLSA. I'm Steve Serbalik. I'm a panel attorney for ASCOPS, and today I'll discuss the Fair Labor Standards Act, what it requires, and what it would take in order for government agencies to lawfully declare lieutenants exempt from the Act's term. This is a general topic summary and not legal advice. So before you act upon anything in this video, make sure that you talk to a lawyer. The FLSA is long and complicated, but the central points for the purposes of this video are these. Number one, employees are entitled to hourly wages, not salaries, unless the employee's duties qualify them as exempt from the FLSA. Number two, the Code of Federal Regulations details how the FLSA will be applied and essentially states that law enforcement officers and firefighters who respond to emergency scenes are generally considered covered employees under the FLSA. Number three, in order for an employee to be exempt from the FLSA, they would need to qualify under what are known as the executive, administrative, or professional categories. I'll start backwards with number three, the executive, administrative, and professional exempt employee categories. There's lots of litigation as to what these categories mean. And fortunately for the length of this video, you can cross off the professional category from consideration. 29 CFR 541.4 states that individuals in law enforcement do not qualify under the professional exemption. Now, generally for first responders, know that 29 CFR 541.3 says that FLA exemption is not applicable to police officers, quote, regardless of rank or pay level, who perform work such as ... rescuing fire, crime, or accident victims, preventing or detecting crimes, conducting investigations or inspections for violations of law, performing surveillance, pursuing, restraining, and apprehending suspects, detaining or supervising suspected and convicted criminals, including those on probation or parole, interviewing witnesses, interrogating and fingerprinting suspects, preparing investigative reports, or other similar work. So now, again, working backwards, let's consider administrative. The administrative exemption only applies to individuals whose primary duty is the performance of office or non-manual work directly related to the management or general business operations of the employer, and whose primary duty includes the exercise of discretion and independent judgment with matters of significance. Additionally, for law enforcement, the provisions of 29 CFR 541.3 say that police employees do not qualify as exempt administrative employees because their primary duty is not the performance of work directly related to the management or business operations of the employer or the employer's customers, as required under a different section of the law. Now, the one that many agencies used to attempt to classify lieutenants as exempt, the executive exemption. In order to qualify under the executive exemption, an employee needs to have the authority to hire or fire other employees or whose suggestions and recommendations as to the hiring, firing, advancement, promotion, or other change of status of other employees are given particular weight. This particular weight language is defined in the law. Factors include, but are not limited to, whether it is part of the employee's job duties to make such suggestions and recommendations, the frequency with which such suggestions and recommendations are made or requested, and the frequency with which the employee's suggestions and recommendations are relied upon. Generally, an executive's suggestions and recommendations must pertain to employees whom the executive customarily and regularly directs, and does not include an occasional suggestion with regard to the change of status of a coworker. So, to apply this to police lieutenants, the job of police lieutenants at most mid-size and major police departments does not include hiring and firing authority for employees. And simply having lieutenants sit on oral boards or hiring panels has been litigated and deemed insufficient to meet this executive criteria. Now, this makes sense as patrol lieutenants at many agencies have little to no real input on personnel decisions. These decisions are made by panels composed of many ranks or are chosen by captains or commanders. Additionally, the CFR also makes it clear that a police officer whose primary duty is to investigate crimes or fight fires is not an executive merely because the officer or firefighter also directs the work of other employees in the conduct of an investigation or fighting a fire. In other words, if a lieutenant is responding to emergency calls and actively engaging in investigations or tactical circumstances, and that same lieutenant doesn't have hiring or firing authority or significant impact on personnel decisions, that lieutenant is covered by the FLSA and is entitled to hourly pay protections. Agencies can't try to save money by deeming lieutenants exempt, forcing lieutenants to work as salaried employees, or denying lieutenants overtime. Violations of the FLSA create 3 remedies: back pay, liquidated damages, and reasonable attorney's fees. Essentially, what this means is you receive double your applicable back pay, and your employer would need to pay attorney's fees. Now, taking all of this together, this area of law is extremely complicated. There can be some lieutenants or even some sergeants who could receive salaries under the FLSA if they have true hiring and firing executive authority, or if they're engaged in purely administrative tasks that don't involve law enforcement investigation. It isn't the rank that determines whether someone is exempt from FLSA, it's job duties. That said, most mid and large agencies that I work with cannot lawfully exempt all lieutenants from hourly wages, as the job duties and responsibilities assigned to most lieutenants qualifies them for protections under the FLSA. If you have any questions or comments, please feel free to leave them in the comment section down below. Remember to like, subscribe, and turn on notifications to help my channel grow. And as always, please share this video with others that you know might find it helpful. And be on the lookout for future videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Cerbalic. Thanks for watching and stay safe out there.